Burlington.
And Carolyn is like, she's on her second round.
Oh, yeah.
She was in the House, then in the Senate, then took a break, and now she's back.
The House is best.
Good morning.
Molly Burke from Brattleboro.
Troy Hedrick from Burlington, a portion of it right around campus and the hospital.
Patty McCoy, representing the towns of Pulteney, Ira, and that portion of Wells west of Route 30.
Good morning.
Morning.
Okay, so it looks like, Damien, it looks like you're supposed to call the meeting to order.
Great. Well, for the record, I'm Damien Leonard from the Office of Legislative Counsel, and I hereby call this meeting of the House Sexual Harassment Prevention Panel to order. The first order of business is the election of a chair. So are there motions?
I would entertain a motion to elect Molly Burke as chair.
I'll second that.
Okay.
I guess you don't have
Thank
to
you.
second nominations, do you? You don't have to second nominations.
Yeah,
Sorry.
it's okay.
Second
Oh, all
it
right.
Anyway.
Procedurally, it feels good.
Yeah.
Are there any other nominations? Seeing none, all those in favor?
Aye.
Aye.
Okay. Motion
Thank you. I
carries.
appreciate that. I'm happy to do this again,
Good.
and that we really have a policy.
That institutional knowledge there, especially since you shepherded us through the.
Right, we were just
reforming
talking
of our-
about that. What was it?
Years.
April 29th? Was it?
April 29th,
Yeah.
2022, finally
And-
adopted.
And I want to report that the Senate is meeting today and Senator Clarkson printed out our policy last night, so.
So they're just going to adopt
aware of
ours,
what it
or
is.
they're going to adopt ours, or
I think it'll be a longer
Yeah,
discussion,
I think,
we figured that's why we didn't want to wait in the
all
last.
right.
but
Yeah. Well,
yeah,
I think that seems to be very, wants to get this done.
Yeah.
So,
So each biennium, the panel needs to readopt its policy and rules of procedure. So it's really up to you, Madam Chair, whether you want to vote on it, whether you'd like to do a walkthrough, whether you'd like to vote on it and then do a walkthrough. So there was the last year's panel adopted the policy and rules of procedure that are currently on the website. That's what we were trained on during the sexual harassment prevention training. But obviously the panel has 2 new members this year. So really,
I think it would be helpful for a quick overview of what the policy is to orient new members. And then we can decide whether we want to have another meeting to, go deeper into it. I'm sure there are probably a lot of questions about, procedure, et cetera. But I would also, I think having worked on this for so long and finished it, I don't feel any need at this point to change anything unless some issues come up. That's my feeling. I don't know how the panel feels.
So I just, this policy stays in place until we adopt another one, or do we have to adopt this one?
the way
How does that?
the House rule reads, if I remember correctly, is that each biennium, the panel shall adopt a policy.
Okay.
So
So
I
we
think-
should formally do that.
I think you need to formally do that. I think if, in the event that we had a complaint, we'd proceed under the,
So should we formally adopt this one, and then if we need, and then go through it, and then should the need arise to change it? That way we know it's in place like today. Correct?
yeah, you could
Once
do
we
that
adopt,
and
it's
then,
ado- And then if there's.
exactly.
Okay.
Yeah.
I think that's the prudent thing to
Okay.
do, since we just adopted it April 29th.
Absolutely.
Left the building May 12th.
Right.
So
I
Okay.
agree.
So
Yeah.
you want to make a motion?
I'll make a motion to adopt the House policy on prevention of sexual harassment as adopted May 29th, 2022.
April 29th.
April 29th.
Oh, what did I say? May?
May.
Sorry.
Do you,
Just like my vote yesterday, April 29th, 2022.
do you want to include the rules of procedure that
Oh,
you
as well
adopted
as-
on the same day?
Yes, as well as the rules of procedure.
Okay. All those in favor?
Aye.
Any opposed?
Okay,
Okay, there we go.
great. So I will I don't know if we need to, I'll talk to Jen about whether we should, and Betsy, just to see if we should make a note on the procedure that it was readopted on February 1st. I don't know that we need to do that. This is on the record, so. So that actually is probably the starting point, if you'd like me to start an overview.
Yes.
So last April, the last biennium's panel voted to split the policy and the rules of procedure into two separate documents. The reason being that many of the policy is, at this point, is pretty well refined. The rules of procedure are, I think, a work in progress is a good way to describe it, because the panels are so new that we're still discovering things in the rules of procedure that when we adopted them, we thought they made a lot of sense. And then sometimes when you get a real life situation, you realize that it doesn't work as smoothly as you hoped. And so the other piece with the rules of procedure is now it's been broken into numbered rules. So we could, the panel could just do, for example, an amendment to Rule 1, which is the definitions or something like that, if it felt it necessary, rather than taking apart the whole document again, which is a meeting after meeting after meeting after meeting process, and can be quite time consuming and challenging to do during the session. So turning to the policy, which is probably the most important piece of this, it prohibits sexual harassment and retaliation for reporting sexual harassment in the House. The Senate also has a policy. It is not the same policy. So prior to the start of the meeting, you may have heard us discussing that a little bit. They have an older version of the policy. At one time, the Senate and the House had the same policy. But last biennium, the Senate took up the policy with only a few days left in the biennium that the House had just adopted, and didn't have enough time to finish even going through it the first time. So my understanding is that Senator Clarkson intends to start the process of doing that review with the new Senate panel today. And hopefully we'll get close to at least having the policies identical. And then the rules of procedure have always been an area where the House and the Senate have diverged, because their structure, they use the Senate Secretary's office to provide counsel to their panel, whereas this panel uses legislative counsel. So, but there can be a joint panel between the House and the Senate if there's a complaint between the two. So for example, if a senator complains that they've been harassed by a House member or vice versa, a joint panel can be instated. Same thing if, for example, someone complained that a member of legislative council had harassed them, a joint panel would sit. The policy regulates all representatives and staff who work in the House. And likewise, it would apply to joint office staff and it gets a little confusing here, and the joint panel would potentially have to resolve some instances whether the House or the Senate policy applies in a complaint against someone from one of the joint offices. Sexual harassment is defined under the policy as sexual advances, requests for sexual favors, and other conduct of a sexual nature when submission is made explicitly or implicitly a term or condition of employment. Submission to or rejection of the conduct is used as a component of the basis for employment decisions affecting the individual. Those two are often referred to as quid pro quo harassment. And then the final one, which is what we are probably more concerned about in this environment, is when the conduct has the purpose or effect of unreasonably interfering with an individual's work or creating an intimidating, hostile, or offensive working environment. So while there are significant power dynamics in the building, if the harassment occurs between staff or between members, there's often not a power dynamic where there is as much of the potential for quid pro quo, but there is a lot of potential for a hostile or offensive working environment here. It can be verbal, physical, auditory, or visual, or any combination of those, and can be communicated by any means. It can be subtle, it can be overt. And it's not just unwelcome conduct, but conduct that's personally offensive, fails to respect the rights of others, lowers morale, interferes with work, violates a person's sense of well-being. Harassment can occur between any two persons, regardless of their position or gender identity or sexual orientation. There is a list on page 2 of a variety of examples. Just make sure. Okay. And so it's important to note the final example or the final bullet point on page 2, that off-duty conduct that falls within the definitions or examples would also be a violation of the policy if it affects the legislative work environment. So we do not have jurisdiction over what someone might do at their job outside of the legislature or on their own time when it doesn't affect here. But if something happens down the street at Charlie O's or the Three Penny or something like that, that affects the legislative work environment because it involves people who work in the building, then it can fall within the policy. So the policy provides multiple options for individuals who believe they've been sexually harassed. The first is to identify objectionable conduct and just to ask the individual who engaged in it to stop. I didn't appreciate that comment. Could you please do that in the future? The second is to contact the panel. So any person can contact this panel informally. An informal contact can just be to ask questions. I saw this happen today. Is that something that violates the policy? I'm a little concerned about it. Or it can be to begin the process of seeking an informal or formal resolution of the issue. The second option for employees is to contact their supervisor. Likewise, in the House, there is always the potential of contacting your caucus leadership or the Speaker's office if for some reason, ideally people would come to the panel, but sometimes they feel more comfortable going to the leader of their caucus or to the Speaker's office for a variety of reasons. The next is to contact the Office of Legislative Human Resources. So Arlene and Eliza would be available to any person who believes that they've been harassed in violation of this policy. And individuals are always permitted to pursue other options outside of the policy. There's no requirement that you try to resolve things internally. In some instances, people may just feel intimidated by the environment and be afraid to pursue resolution internally. If that's the case, they can speak to the Human Rights Commission, the Attorney General's office, or hire a private attorney. The only exception is that if the individual who was potentially harassed is or appears to be under 18 years of age, the policy requires immediate notice to the Chief of Capitol Police and the Sergeant at Arms. And the reason for that is because of the risk of any sort of sexual assault or sexual offenses against a minor. And we're particularly concerned about that because of having interns and students and pages in the building, we want to make sure that they're protected and kept safe at all times. So there's a mandatory report requirement in here. The panel and any supervisors, the Office of Legislative Human Resources, and then any staff to the panel are required to keep any complaints and information they receive under the policy confidential. So my basic guidance to the panel would be, when in doubt, ask legal counsel if you can make the disclosure. So typically disclosures are limited to panel members, counsel that's providing assistance to the panel, and the parties involved in the complaint. Sometimes if there are witnesses, they will also be brought in. We do not have the authority to discipline people who are not part of the panel or on staff for violating that confidentiality. But we would encourage everybody who's involved in a complaint to maintain that confidentiality. It's important to note too, and this is the first point where we touch on it, each of these options I'm going to set out for you in a minute describes a way for the panel to resolve the issue. If the individual does not want to proceed with the resolution, the panel has to make a determination as to whether there's a potential for additional violations to occur. If there is, the panel needs to take prompt and appropriate action to make sure that doesn't happen. So those are instances when we may not be able to follow the wishes of someone who's experienced sexual harassment, because we have a duty to make sure that other individuals in the state house and in the house don't experience that behavior. So if we become aware of behavior that may repeat, or behavior that is a repeat of maybe a past incident that the panel resolved, there's a duty to act and make sure that that stops. So the individuals, when they come to the panel, they can seek what's called an informal resolution. There's no formal complaint filed. And the process usually involves two members of the panel trying to mediate a resolution between the parties. Sometimes both parties are present for that. Sometimes it becomes sort of shuttle diplomacy, where you speak with the person who feels like they were harmed. You then go speak to the alleged perpetrator, and you may do a back and forth. And sometimes that can involve potentially other parties who witnessed or were affected by the conduct. So one of the potential options for something like that is, if it involved several people, you could do something called a restorative circle, where you actually bring the parties into a room and you let them all discuss what happened, how it made them feel. And the idea is hopefully that the panel members lead them to a point where they can resolve the issue and agree that what happened isn't going to reoccur, and there are apologies made, and the harm is healed. In more serious instances, or if an individual wishes to pursue it, we have a formal procedure, which involves a number of steps that are laid out in the rules of procedure. Importantly, if you receive a formal complaint, and so the process is basically, you receive the formal complaint, you review it. If it states a claim on its face that could be a violation of the policy, so just assuming that everything in the complaint is true and accurate, you then move on to allow the other party to respond. When that party has responded, you again review the complaint, and if, based on all of the context you have, it still looks like it could be a violation of the policy, at that point, the panel would bring in outside counsel or an outside investigator. this is getting outside of the policy and into the rules of procedure, but that is an involved and time-consuming process. We do have outside counsel retained now. Lin, Blackman, and Manitsky has been retained by our Human Resources Office to assist the General Assembly with employment matters, and then potential discrimination issues from sexual harassment to discrimination, as well as ensuring that we're complying with the ADA if we have requests that we're not able to accommodate immediately. So, but they would be brought in and potentially at that point begin staffing the panel. Most likely at that point, Legislative Council would step back because of the potential conflicts of interest we have. We work so closely with so many of you that there are just very many instances where we find ourselves where we're potentially torn between 2 or 3 different parties in there, where we're working with people closely on other bills and other issues outside of the room, and it becomes virtually impossible to sort of partition our brains and our functionings, that we're not somehow compromised as we're trying to provide that advice. But so that's just to say that the formal procedure is an option for people. It can end in a hearing with a formal recommendation of discipline, but it is a long time consuming procedure. For less egregious conduct, it's often easier and quicker and gets better results for people if we can do an informal resolution that stops the behavior and that heals any harm that's been done. Again, we have that formal procedure so that we can handle more serious conduct or repeat conduct. So the page 4 sets out the potential penalties following a formal procedure. For representatives, the penalties can include counseling, training, removal from a committee or committee leadership, censure, and ultimately potentially expulsion from the House. That would require, both that and censure would require a full vote of the House. It would require the panel to introduce a resolution and then the House to pass the resolution. Those are both very, very significant penalties and would require a significant amount of time and work.
Damien,
Yep.
can you give me an example of what an offense might be that would require that?
That's a good question. We have never had something that serious in my time here.
Were you here when Senator McAllister?
I was here for the incident with Senator McAllister. So that actually brings up an interesting point. There is a provision in the rules of procedure that allows the panel to stay its proceedings pending the outcome of a criminal investigation. So, and that's
Requires. Allows, but not requires.
allows but not requires. So, and the reason for that is, so with Senator McAllister, I'm not going to comment on the particulars of the case.
And he was eventually found to be not guilty.
Right. He had his trial. He was eventually exonerated at trial.
Yeah.
The incident there involved, as I understood it at the time, involved primarily potentially criminal conduct that would fall above and beyond what's in the policy. It could have involved some sexual harassment, but it's important to remember that sexual harassment is a civil offense. So if the conduct had involved, and I'm just gonna, let's move away from from Senator McAllister. If the conduct involved something where an individual was accused of both sexual assault and various instances of sexual harassment, the panel could decide we're going to ignore the criminal investigation that's going on with the sexual assault. We're going to proceed just on the facts related to sexual harassment. Or they could decide they're so closely intertwined that we would prefer to let the criminal proceeding resolve itself before we move forward with a resolution here. And it really is going to become a fact-specific thing. When you get to censure and expulsion, though, it would have to be severe, pervasive conduct that violated the policy. Because at that point, you're talking about something where not only the panel has to likely vote unanimously to support that, but then you have to bring it to the House floor and convince your colleagues to support literally either publicly censuring someone or removing them from their ability to do their elected job. And those are extremely severe penalties.
Yeah.
From the House's perspective. So that's potentially difficult. With the case that you mentioned, the Senate had removed the senator from committees. And that would be an easier penalty to apply. So we list censure and expulsion here as sort of the ultimate penalties that could be imposed. It would be my hope that we never have conduct in this building that is that severe, that we would get there. And also that we capture any misconduct soon enough so we don't get to a point where severe or pervasive harassment can occur. So, and that's, I think that's just something that's worth noting is we list the range of penalties, but it's up to, and that's sort of the final ability that the panel would have would be to recommend expulsion of a member if, for example, there had been repeated violations and the panel had imposed training and had imposed counseling and the individual had been removed from a committee and the conduct continued. At that point, you could seek to expel them from the House. But it really would be a case by case basis. So
Thank you.
that was a good, hard question. Thank you. With the House clerk, the corrective action could also include counseling, training, censure, or removal. Removal of the House clerk or censure, again, would take a vote of the body. So the House clerk is elected by the House, and the House, as I understand it, would need to vote to remove the clerk as well. And then if it's an employee, the penalties, again, counseling, training, and then they move on to reprimand, loss of pay or vacation days, demotion or termination. And in those cases, the recommendation's made to the supervisor. So the bar for employees, there are more penalties that you can impose and a broader range of penalties that you can impose on employees. But it's important to note that like the other penalties, ultimately the panel's ability is to either get people to voluntarily agree to engage in counseling or training, or to request that a higher authority impose the penalty, whether that be the whole House or a supervisor in one of the legislative offices. Are there questions? Any other questions on that? Okay. So interns, staff, and volunteers are also protected by the policy. We do have a requirement that any representative that employs an intern or a staff person or accepts the services of a volunteer to do legislative work has to provide the sergeant at arms with their name, address, and contact information. And if that individual is a minor, they also need to provide the name, address, and contact information for a parent or guardian. And the sergeant at arms is required to ensure that those individuals all receive a copy of this policy and are aware of their rights.
So Damien,
Yep.
should all of our, whether they're minor or not, should all of our interns get copies?
They should, if they're through the UVM program.
They do.
We've handled that through the UVM program. Probably the biggest, so when we have a formal program with a college or university, and Arlene can talk about that more, we work with the program to manage getting them training and materials on our policies and so forth. And there's usually an extensive agreement. The place where we have potential issues is when people bring on an intern that's not through an official program with the legislature. So they bring on a personal intern. We do have, the Office of Human Resources has a notice of personal intern form that individuals can fill out. That includes this information. It also notifies members that depending on the work they have the intern doing, they may be liable under other employment laws for things like minimum wage. Because of there are various laws around when an intern can be unpaid because they're receiving college credit and getting an actual educational experience versus having to be paid because they're doing things like constituent work and they're no longer receiving an educational benefit. It's not to say doing constituent work can't be educational, but there's a point where there's a sort of balancing question that goes on in the courts. And that's not something that either our Office of Human Resources or Legislative Council assists members with because it's a personal decision of members. And so we include a disclaimer that members need to, potentially seek the advice of counsel just to make sure that they're not violating any employment laws there. But that's where we have the biggest concern. Back when I started here, there were no official intern programs, and that's when this language first came out. And since then, we've standardized a lot of the intern programs, which I think has helped a lot because we can roll the training out to them as a body instead of trying to track people down individually. Other questions?
The UVM intern program is really excellent. Really very supervised, in all ways. It's really terrific.
Yeah. Let's see. So the next part of the policy talks about training and information. Essentially, you've already had the training done. That's required under the policy when we had NCSL come in and do the training. And then the policy is posted on the General Assembly's website. And then the last piece, it's not covered in the policy, but just is that all five of you are sources of information for your colleagues. And if you don't know the answer to a question, Arlene and I, or Jen Carby, are all sources that you can go to for assistance. And then Katie Micklin and Mike O'Grady are also familiar with the policy and could provide assistance to the panel if you have questions when someone comes to you. And that's not an unusual thing. Oftentimes people have questions about a unique situation, and it's tough to figure out exactly where it falls, whether it falls under the policy or not. The other resources are listed at the end of the policy here. And it's important to note just the last paragraph provides that individuals are not required to file a complaint. before contacting the Human Rights Commission or the EEOC or the Attorney General's office. I didn't mention the EEOC before because the Attorney General's office is actually their local. An EEOC complaint gets passed right over to the Attorney General's office in Vermont. So they investigate under both the federal and the state law. And that's it for the policy overview. I'm guessing we don't have time for the rules of procedure today because it's.
Probably not. I have a question, Damien. Remember at the end when it says here, and the House panel is authorized to appoint up to 3 members of the House to serve as sexual harassment prevention facilitators.
Yes.
And I think that we just got to that point. Did we had named some people? What, I can't remember where we got to with that. It seemed like we sort of asked a few people or named a few people, but I don't know if we ever really, if that ever really got formalized. I don't know.
Yeah, I think you could consider whether to do that again. And I would start over with, if those people are still in the House, then, ask them again. And so the facilitator role, for our new panel members is they're individuals who would be knowledgeable about the policy and could help their colleagues sort of understand what their rights are if they're concerned about speaking to someone in a position of apparent authority with respect to the policy. Because they're concerned that it's going to start a process that they're not ready for or something like that. We've used the facilitator position in the staff offices in the past and found it helpful, especially for newer staff who are not comfortable moving around the building, not sure who they can talk to, not sure what the power dynamics are. And they found it helpful to be able to speak to someone who wasn't in a position of authority and just get information about what the next steps could be and how they could proceed. So,
And by definition, should be separate from this panel.
it has to be separate from this panel. And the reason, there are a couple reasons for that. First is it takes away that apparent position of authority. The second is the panel has an obligation to take action regardless of whether a person's ready. So having someone who's separate from the panel may provide them with some breathing room before action has to be taken. It is designed to be kind of an informational thing if people are afraid about triggering the panel's process.
Right.
So it's not something you have to do, but it is something that you can do if you think that would be helpful to House members. We, at this point, don't really have facilitators for staff currently. So I imagine people might still go to Katie. I'm so closely involved right now with the panels that I'm not sure I can continue to perform that role for staff. So that's just something to note, is that the staff aren't necessarily using that right now that I know of.
Staff are not using the facilitator
Yeah,
for your staff. Yeah.
yeah.
Do we remember who we,
I don't know if we did a formal,
I think we sort of came up with some names and
yeah, but I don't know if we got any farther.
So late in the session. I
Right.
don't know whether
That's
we ever
right.
actually asked anybody
I don't think
formally.
we did.
And you were going to look at 3. Did I hear you say 3?
3, yeah, we'd said there were three potential facilitators. I think it's a good idea, actually, because
Yeah.
for all the reasons you said, that gives a little bit of a buffer. Well, maybe we should think about a next meeting and think about that and think about who we might, who might fulfill that role. Somebody who would generally people would feel comfortable going to. I think that's, somebody. Anyway, so shall we schedule another meeting? I think we need to, yes. And what are people's Fridays like this?
Tends to be a good time for me.
It's a good day and time.
It's a good day and time, yeah. We start a little later, so it gives a little, let me just check my calendar. Damien, are you available?
My next few Friday mornings are open at this time.
Okay, great.
Yeah, as long as we start at 8:30.
Yeah, right.
It's,
And we, definitely need to be out of here by 9:20 to get to Flora. That would be February, is the 3rd, the 10th?
And then the 17th, you want to go?
9, 10, okay, I've got it. I'm available.
Is that
February
available
10th?
Next Friday?
Next
Next
Friday.
Friday, yeah.
I'm available the 10th and the 17th.
Okay.
Well, we could reserve the 17th in case we need it, yes?
okay, so you want to do next Friday and possibly the 17th?
Yeah, that's what I was saying.
Okay,
Yeah, let's say next Friday for sure, possibly the 17th.
great. And Lindsay is, I think, prepping the meeting request behind us, so,
She is on it.
yep,
Lindsay is outstanding.
yeah,
Thank you, Arlene.
great. Okay.
She's muted.
Thank you. Yeah, I was muted.
Bye-bye.
Thank you.
Have a good day, everybody.